Many of you are concerned about the possible influence of money in a constitutional convention process. We have questions such as, could Mayor Bloomberg drop a few $1 million in Rhode Island to make it a gun-free state? Will big money and Citizen United pervert the delegate election process? And that's from James Arisia, I think. Is there a case that the better funded state will prevail on all levels? What would make the Constitutional Convention any difference? What mechanisms besides new environmental confusion will prevent lobbyists and money from influencing the delegates? And that's from Steve Oquist. And will organizations such as the ACLU be able to lobby the delegates? So, who would like to respond to this money and influence and what role that would play in a constitutional convention? Steve?
Yes, we will lobby the delegates, they just won't listen to us. That's actually a very good question. Even before Citizens United, the Supreme Court has ruled that there can be no expenditure or contribution limits on referenda campaigns. This is different from candidate campaigns. So, in answer to the theoretical question, yes, Mayor Bloomberg could put $10 million into a campaign on a gun amendment or any amendment that comes out of the convention, or he wants the convention to consider. It's true of any interest group, and that's why, one of the points that came out earlier from Professor Williams is there's now a national, this is now a national trend to use state constitutions in order to promote ideological driven goals, and there's no limit. Just to give you a ballpark number, according to this report I have in terms of 2012 ballot measures, there was over $939 million spent in dealing with contributions on ballot issues across the country. So I think that gives you an idea of what we could expect from a state constitutional convention.
Anyone else want to speak to this?
Yeah, I agree with Steve. There can't be any limits placed on this. I'm going to offer two thoughts. One is I don't read into the Constitution that there couldn't be created a public financing system for the election of delegates. And I know I think there was a question that touched on public financing. They have to be from the House districts and so forth, but I don't read that couldn't happen. Others may disagree with me on that. And I actually think we have a recent example of an election that might help us illustrate what this would look like, which is the Exeter recall. So people might be familiar that in the town of Exeter, there was an effort to recall all but one of the members of the town council last fall. It was hard fought between some folks who are pro-gun control and some folks who are pro-Second Amendment. And ultimately the pro-gun control folks, I think you could say, won by retaining the people in office. It was a very local question. But there were outside national interests and groups who did come in. I haven't gone back and tabulated all the money that was involved. There were significant amounts of money, but they weren't $930 million. This is Rhode Island. A House district has about 12,000 people in it. And so, this is not California. This is not Texas. This is not New York. You can run an election fairly on the cheap. And in all likelihood, these delegate candidates are going to be knocking on doors. Not to, we're in the money in politics business and common cause, not to say money in politics isn't important, but I would actually expect that it'll be ground game groups who are more influential in the delegate selection process, and the money will come in on the back end with the actual referenda being on the ballot.
Professor Williams?
Just a very quick point. As Al and Tara mentioned, if a convention is approved, it will decide for itself most of the internal operating questions, and one of those might be whether to impose the convention's own lobbyist registration requirement, and expenditure disclosure requirements. Sometimes these things get sort of forgotten when you have a convention.
Professor Goldstein?
Also, I mean, to the extent that the fear is that there'll be backroom deals being made by influential and powerful outside groups. I mean, I think a lot of, although I think that is something to be concerned about, I think this sort of concern can be addressed, at least in large part, by making the convention entirely transparent. I mean, when we think of the U.S. Constitutional Convention, in 1788, it's a bunch of people locked into a room having secret meetings and then deciding, magically what should happen to the country, apparently forever. That's not the process that a constitutional convention that would hold in Rhode Island should follow. They should be open meetings, it should be televised, there should be traveling hearings in which everyone gets to participate. And I think at least one response, to the concern, again, a legitimate one about the use, that the influence of money is sunshine. That is, everyone should know what's happening and everyone should be able to see exactly what's happening and be able to participate in what's happening.
Any other comments? Professor Tarr?
I think you have to sort of disaggregate what the issues are going to be on some matters, such as whether or not you have a line item veto. This is not going to interest national groups. It may not even interest the citizenry of the state. So I don't think that you can assume that there will be huge amounts of money with regard to all these issues. There are some things which are hot button issues. Mr. Brown has identified some of those, and if those become part of the agenda, one expects that there will be groups that will be coming in. The other thing to mention is why will this money be effective? One of the ideas usually is that if an individual is susceptible to the influence of money, it's because he or she wishes to advance their career, gain re-election, etc., etc. Again, although it may be that individuals who serve as delegates have hopes of becoming political figures in the state down the line, this is a temporary position, and many of those who are delegates don't have to worry about re-election.
Okay. Another topic that seems to concern many of you is sort of how bad could it get? Sort of what damage could a Rhode Island a constitutional convention do? And we have questions such as, what is the floor for the rights of women, the right to choose, how much could this be changed by the Rhode Island Convention? That's Liz Head. Others have suggested if we already have these rights protected by the U.S. Constitution, why can't individual rights be taken off the table as a topic at a convention? Again, if rights are already protected, what role would the convention have in altering them? And Judge Flanders.
Yeah, I think it's important to reiterate that the federal Constitution sets the floor. No state constitution can take away federally protected rights that are recognized by the federal courts or through legislation or the federal Constitution. So that's an important safeguard against a runaway convention or a runaway state that tried to deprive people of the rights. And when states have actually done that, the U.S. Supreme Court has struck down attempts to disenfranchise, for example, gay folks in Colorado. So it's important when you consider these concerns about how this could diminish our civil liberties. Remember that nothing we could do, even if we wanted to, could take away our rights that are federally recognized. On the other hand, because the federal Constitution sets the floor, civil rights can be raised at the state level. We can add more rights to the ones that we enjoy at the federal level, at the state level. So, for example, the Victims' Rights Amendment that I alluded to earlier, there is no Victim Rights Amendment at the federal level, but states are free to and have added to our civil liberties through constitutional conventions and amendments to their state constitutions. So, legally, when these things go to court, the courts are duty-bound generally to first apply the state constitutions to decide whether any rights have been violated, and only go to the federal constitution if they're not protected at the state level. So I think that's an important consideration to bear in mind here when you hear these concerns about how our civil liberties could be compromised. That really there is a floor, and that's the federal protected rights that won't be damaged no matter what happens.
Mr. Brown?
Justice Flanders is right. The federal Constitution does set a floor. What he has neglected to note, however, is that floor keeps on sinking. If you've been watching the United States Supreme Court. So in terms of abortion rights, for example, things that states could not legislate over 15, 20 years ago, they now can, and they can do it through constitutional amendment, as some have tried. Affirmative action is another very good example. I may be wrong, but I believe that the case before the Supreme Court right now dealing with affirmative action might be over the constitutionality of the voter initiative. So, in the state constitution. So there's an example of the Supreme Court, I think, ultimately giving approval and lowering the bar in terms of protections for affirmative action based on a constitutional amendment that was approved by the voters. So it's a very real danger. The fact that there is this floor does not provide the protection that we think is absolutely critical.
By the way, I'm much more comfortable being seated to the right of Stephen Brown.
And I guess as a follow-up question to that, a question was submitted is, do we, and I guess particularly for you, Mr. Brown, but for everyone, do you have any reason to believe, are there data or polling that suggests that Rhode Islanders would be prepared to limit individual rights?
I certainly have done no polling. I think, again, I look at history about what happened at the 1986 convention. As much as we want to try to ignore it or put the nicest gloss over it, there was not just the anti-abortion amendment that did not pass. There was another anti-abortion provision that did. And then there were the two anti-civil rights provisions that passed. I just don't believe there's any evidence to suggest that we should see something different. And I think if people want to say that's what I'm saying is really just made up stuff, why should we worry? I think relying on history is a legitimate basis for doing that, and I ask the others to say, tell me why I shouldn't be worried based on that history.
I think that there's reason to worry. The people can often make mistakes. The people can try to take away rights. But whether or not they'll be effective is another thing. That is, in '86 they passed, the convention recommended as an amendment that life begins at conception. First, two things happened. The voters didn't approve it. Second, if they had, it would have been struck down as unconstitutional because the Supreme Court has held that that kind of amendment is unconstitutional. So there are two different levels of protection for when the voters make mistakes. So I think that there's reason to think that that voters will not, and the people in the convention will try to take away individual rights. But then groups who oppose it will have their chance to say that you shouldn't be allowed to do that, and even if that succeeds, then the courts will be there to say ask whether or not they went below the constitutional floor.
Mr. Sass?
Yeah, I just think it's important to put in context what the baseline is for history. The baseline is 1986. You come to one possible set of scenarios. The baseline is some things that have happened in the society after 1986. You probably would come to a different set of scenarios. And that's true if you go out and trace the total constitutional history of the country. You know, slaves were 3/5 of a person at one time. Well, that's not going to be discussed again. And I would argue that the changes made to protect civil rights and minority rights since '86 are a much more valid historical baseline than a convention of '86. And the other thing I would argue, and this is where process is important, if Steve and I can compare war stories on what happened, he started to tell them. I think if it's done with appropriate process and safeguards, you can build in some protections to some of the abuses that happened in organizing the '86 convention.
Okay, we have a series of questions on the particular process that's gearing up here in Rhode Island. One question is there a set scheme for the delegate election? Must it wait until 2016, or is there a way to have it more quickly? Another one asks about this recent Senate proposal about the appointments to the Bipartisan Preparatory Commission, and what that seems to try to make the Preparatory Commission most of the members be members of the legislature. What do the panelists think about that? And a sort of general question of how effective has constitutional amendment through non-constitutional conventions been in recent history here in Rhode Island? So who wants to address some of the delegate procedural issues in the Senate?
I can start with the Senate. So the Senate resolution, as the question talks about, primarily gives the picks of the people on the Preparatory Commission to the legislature. I believe that was the same in 2004. And I wouldn't expect anything different. Generally, any legislatively created advisory commission now is full of legislative picks. And I think the people of Rhode Island will have to wait and look at the product in light of that, right? So you have to discount what that says, given who says it, depending on your perspective. There are two alternatives. One, the people could convince the legislature to pass a more representative group in the resolution, so they could amend that, pass something different. Or, as I think is the likely scenario, as I said in my remarks, I think this will probably fall on the governor to create this commission. People could try to implore the governor to create a more representative body. That said, I think in '84, Common Cause, 2 Common Cause board members were on that commission. So the delegate selection process, as I said, we really only have the experience from 1984 to '86 to go on, and so we were talking during the break about New York. There was this, and I don't know if you would rather tell this story, but in New York, when this question came up, people wanted to know what the delegate selection process was going to be before the question was ripe on the ballot. I don't know if we could, see that in Rhode Island. My understanding of Article 14 is, the steps are pretty clear. The yes/no question in November, the General Assembly passes the statute within the parameters of Article 14, and then there's the special election.
Mr. Sass? And generally, you've been asked, Mr. Sass, tell us about your experience in the prior preparatory commissions. This might be a good time to talk about that a little bit.
That's what I was fixing to do, and I wouldn't pay a whole lot of attention to the preparatory commission. The preparatory commissions I served on did not have the staffing to go sufficiently deep into the issues. They were certainly impacted by the leadership. I think in some cases I was appointed by the majority, in other cases by the minority. When I was appointed by the majority, I knew what was expected. And so I'm not sure, while the preparatory commission makes sense as an abstract, the actual operation of it, the time it has, the depth it goes into, the method of appointment, I'm not sure what influence that has on anybody's judgment about going forth, with a convention. And the process is political, so the preparatory process is just as political. The first one I served on, former Governor Dennis Roberts chaired that. I think the very, first one. And Steve was right when he mentioned this morning the issues in the first report weren't all that different from the second and third report. And I interpret that, to be kind of systematic, or symptomatic rather, of, what I described, not having resources, having time frame, and I'm not sure who actually was influenced by the work of the commission. It really wasn't very deep. I think that's summarized.
And if I could comment just on this, I think that the preparatory commission is actually extremely important, at least if history is any judge, not because the convention follows what the commission does, but I think what it can succeed in doing is drawing voter attention and citizen attention to the issues, so that they know about the fact that there's a referendum coming up, and they may have some idea, because of the work of the commission, about the range of issues that the convention could decide. And in '84, the preparatory commission met, they issued a report, and their commission recommended that the voters approve the referendum for the convention, and in fact, then the voters did. In '94, the legislature was so late in appointing the commission that it never met. And so it issued no report, and there was no attention drawn to the issue of the referendum, and the voters voted down the referendum 60-40. In 2004, the commission met, it issued a report, it got a lot of media attention, they didn't make a recommendation one way or the other, and the referendum got 48%. So at least history suggests that the work of the commission bears some strong relationship to whether or not the referendum passes, because it brings voter attention, given the significant problem of voter indifference to the set of reform issues that we're talking about. Having a commission that holds meetings, issues a report, gets news coverage, I think matters a lot in terms of getting the voters informed of what is coming in the referendum.
Mr. Sassia.
Yeah, I understand what Jared's speaking about. I'm not sure that you can make that clear causal effect relationship. So, for example, in '94, the convention was turned down significantly. But what happened prior to that was the Right Now Coalition, a really strong citizens' effort to keep people informed, and the legislature agreed to put constitutional questions on the ballot. And so in '94, even though the commission was appointed late, a lot of what would have happened was other environmental kinds of changes. '84, I think that was the first group that worked on that. And if I was cynical, I'd say it's gone downhill from that point. The chairman of the '84 group, if my memory serves me, was Dennis Roberts, who was a former governor, who was well versed in those issues, and had a certain amount of, he was an active lobbyist too. Their law firm at that time was involved in lobbying, but had a certain amount of experience in political gravitas, with the issues. So I'm not sure what the cause effect is. There's a lot of environmental factors out there.
Yeah, Judge Winters.
On the issue of the order, it's clear under the Constitution as it now exists that the first issue that has to be determined is the question of shall we hold a convention or not, as opposed to electing the delegate. It's only after that occurs under the Constitution as we now have it, can there be an election of delegates. So that has to come after. Interestingly, the Constitution is silent on when that's supposed to occur. So potentially, if the General Assembly has to provide for the election of delegates, but conceivably, they could drag their feet on that and not provide for an immediate election that year, and the convention could get stalled for a few years or later because there's no time period. So there's another issue that's ripe for a potential amendment.
Professor Williams.
But by the same token, couldn't the General Assembly move earlier so that people would know what the process is? Now, I understand we're pretty late for this, but would now, of course, they could amend it later and say, gotcha. But if people were concerned about whether there would be public financing for election of delegates or, who knows, proportional voting, all kinds of possibilities that are out there to make these elections somewhat different, I don't see anything in the Rhode Island Constitution that would stop the General Assembly from enacting that mechanism prior to the vote on whether there should be a convention or not. In response to this concern that we saw in New York in the 1990s, hey, I don't know if I'm for a constitutional convention or not. Who the heck's going to vote? How are they going to vote? We used to call it down south a pig in a poke. No thanks. And it went down in New York for a number of other reasons as well.
Another series of questions, and I think maybe this would do to be good questions for Professors Tarr and Williams, is given what at least seem to be some beneficial effects of these state conventions, how come there haven't been any since 1986? Mel Toth asked that question. And then on a, I guess, related issue, J.H. Snyder asks, what role do organizations such as Common Cause and the ACLU have in preventing these constitutional conventions from happening?
Let me speak very briefly to the question of why there hasn't been a convention since Rhode Island in 1986. And I think the answer is that the public perception of conventions has changed. In the 19th century, there were over 100 state constitutional conventions. During the 20th century, the number has declined precipitously, except during the period right after the Supreme Court's one-person, one-vote decisions, when states had to change the apportionment of their state legislatures. But if in the 19th century, the conventions were seen as sort of opportunities for the people, in the 20th century, there's been a perception, whether rightly or wrongly, that the conventions will be nothing more than the elite or the powerful working their will in a different forum. And you get a good example of this in the New York example that Bob Williams just mentioned. 1997, there was a periodic vote in New York for a constitutional convention. It was endorsed by Governor Cuomo, then Mario Cuomo. And it led in the polls until the final week before the vote. Final week before the vote, there was a barrage of television ads across the state by convention opponents. And in the ads, they pictured sort of your prototypical Paul. They had cigars, they had suspenders, they had the gut hanging over their belt. And they were sitting there talking about how they would be able to feather their nest at the convention. And although you had a great deal of support for the convention prior to this, it was wide, but it wasn't deep. And so these ads turned the trick, and something like 60 to 40% against the convention. People will have conventions when they see some benefit for them coming out of the convention. They don't know about constitutions very much. They certainly don't know about conventions, and they have a perhaps reasonable risk aversion to having one meet. So you have to be able to connect what will happen in the people's lives to what's happening in the convention. Otherwise, they're likely to vote no.
Just to add a couple words, I've suggested, in terms of what Alan said, that in the 19th century it was the politicians and vested interests who were afraid of the people in a constitutional convention. Now it's the people who are afraid of politicians and vested interests in a constitutional convention. And voting, particularly for an unlimited constitutional convention, is a major leap of faith. And we haven't had a lot of faith in this country in government as usual in the last 30 years. So I think Alan has put his finger on it, and it may not change anytime soon.
Mr. Marion, do you want to talk about Common Cause's role or similar organizations' role in, and whether or not they're, I think we've heard from Mr. Brown on the ACLU's role, but we haven't heard much about Common Cause.
So I started my remarks hours ago saying that We had opposed the convention question in 2004, we had opposed it in 94, and the best I could tell, we supported it in 84. There were two Common Cause folks, John Partridge and Chris Little, on the preparatory commission in 1984. And right now we haven't taken a position. We're doing things like this, trying to educate ourselves and educate the public. And we're going to look at what the General Assembly produces this session. I would expect we may come out with a position after the session is over, or we may remain neutral. We would, and to answer there was an earlier question, if there is one, we will be active participants on behalf of the issues we care about, ethics, redistricting reform, and so forth.
Anyone else want to speak to why conventions aren't very popular these days? Okay, so we have a few kind of big questions, such as, you know, there seems to be such deep unhappiness with the General Assembly and the feeling of being unrepresented there. Could or should big radical change come out of such a convention, such as creating a unique type of government in Rhode Island, since we're so small, some kind of city-state system? Should we go back to expanding the number of members in the General Assembly? It was shrunk to 75, should go back to 100. What are the kinds of reforms that could radically alter the current sort of frustration with gridlock? Professor Williams?
Let me just make a general comment about it. In the work that Alan and I have done over the last 30 years, both in the United States and in other federal countries where the component units have their own constitutions, Germany, Switzerland, Argentina, Mexico, Australia, we've noticed that we call it the subnational constitutional space, the room that the component units in our country, states, have to structure their own governments and to promulgate their own constitutions. That space is substantially underutilized. And it's true in all these other federal countries. So for example, we don't have a single state in our country that has in America that has a parliamentary system. There's no reason we couldn't have that. We have one state that has a unicameral legislature that got rid of its upper house and changed the lower house and calls it the Senate. But the range of experimentation with government structures is really quite narrow in our country. And one wonders why there aren't more kind of experimental, because constitutions can operate, state constitutions, through trial and error, why there aren't more, I use the term radical, not in a political sense, but dramatic changes to how we govern ourselves in the states. But I don't want to speak specifically to Rhode Island, but people seem to be pretty hemmed in with what we've had so far, and there's not much in the way of alternatives.
Yeah, I think the reason why people don't adopt any of these more radical changes, although they could, is just for the same reason that why people don't have a constitutional convention in the first place, is the fear of change. That is, if you make a radical change in our basic form of government, you don't know what you're going to get. You think things are bad now, the opposition will say it's going to get worse. I do think, though, that there are some basic changes we could make through a constitutional convention that might be more likely to get broad support in Rhode Island. For instance, Rhode Island is a tiny, we treat ourselves as if we were a state, but I hate to bring it up. We're really like a county. I love Rhode Island, but I mean, we're equivalent to a county in many states. But we act as if we're a state, so we have hundreds of duplicative municipal governments that we could easily, government services we could easily consolidate. That is fire and water and all these other municipal services that each little fiefdom within Rhode Island gets to control. Now, the Rhode Island, because we pretend we're a real state, but the legislature will never adopt that kind of reform, this sort of radical consolidation of services because it's against their interest. That is to give, their constituents will say, what happened to our city service? You sent it away to the big bad, now state government. That kind of reform, I don't think can happen through the legislature, but could happen through a constitutional convention operating independently.
Can I piggyback on that?
Sure.
One thought, this isn't a common cause position, but just, one of the things that makes Rhode Island unique is the lack of county government, right? I believe Rhode Island and Connecticut are the only two states that have functional county government. Well, I'm not the first person to come up with this idea, but consolidation, we have county lines, consolidation under those county lines is something that a convention, I think, would be uniquely situated to consider because of some of the issues we've raised before. They don't face re-election and so forth.
I just want to mention something that to keep in mind when Professor Williams talks about how we haven't really moved into that space of differentiating ourselves greatly from how most other states are organized. Until 2004, Rhode Island considered itself, at least through its Rhode Island Supreme Court, to be a quintessential parliamentary system of government. We had no separation of powers to speak of, and we were almost unique in that respect among our fellow states. So, Rhode Island really, until then, was quite a radical, a different experiment in state government. And obviously, ultimately, the people decided that wasn't so good and decided to amend our Constitution to provide for more separation of powers. Now, have we gone far enough? Some would say no, but I certainly think there's more room for consolidations at the local level. The Central Falls experience that I went through has taught me that we need to have more consolidations at the municipal level. We've got cities and towns that are still in dire financial straits, and it's there's really it's amateur hour at some of these local pension funds. And I think we've got 150 different pension funds that are being administered for our public employees, and some are in woeful shape. So there's things at the constitutional level that could encourage consolidations and regionalizations and combinations that are now stymied by home rule provisions in our existing Constitution that would argue against doing that. So there are a lot of structural things that a Constitutional Convention could consider that could make Rhode Island more efficient and less duplicative at the local level.
Mr. Sass?
And I want to come back to the preparatory commission because this is a very good example. So in the reports of the preparatory commissions, they're pretty predictable. But if you had a real preparatory commission process, and the question that we've discussed today about the structure of government, the issues were outlined, there was some research done, and some explanation, that would be a valuable first step exercise before something came before a constitution. Because when you talk about structure, you're talking about function, you're talking about units of government, how do you balance accountability and efficiency? These are all very basic questions that you want to think about if you were changing the Constitution. And that's where information and evaluation and analysis is needed. So just to go to a Constitutional Convention blind and think that we can talk about changing the structure of government, with the way that we've organized, would make it very difficult to reach conclusions, reach consensus in that.
So a few of you have asked about if we do go forward with a constitutional convention, what mechanisms could we use to guarantee that there's some kind of representation from other than the usual players, that there's representation from in appropriate proportions from women, from people of color, from other people who are unrepresented generally in the political process or less represented in the political process. If we want this to be different than politics as usual, what kinds of mechanisms could make it that?
You're asking this group of white guys to
Not just I didn't mean it in a big sense.
some evidence that public financing of elections has increased diversity in the state legislatures has been used. It certainly has increased the diversity of, I believe, age diversity. I think there's some evidence of gender and racial diversity, but I don't have that off the top of my head. So there's one possibility, is public financing for the election of delegates.
Professor Williams?
Again, I think this is, at least for this go-around, is a matter that's left to the General Assembly. And I take it that a lot of you are not very optimistic about convincing the General Assembly what to do, but that is the focal point right now. And there are a number of, I'm not an expert on this, but there are a number of possibilities. One is public financing. There's all kinds of mechanisms of proportional voting, different ways to weight voting and things like that. They're not magic, they're not automatically effective, but they do address this kind of question. Now, what the likelihood is of your legislature adopting those kinds of mechanisms, I don't know. I think I can sense from this group what it is, but those are things that could make it a little bit different from government as usual.
I think if you examine the demographic data, you'll see very quickly that the state is going through radical transformation in terms of what we look like and who we are. And that demographic transformation will be, and it is being reflected in our politics right now. So I think it's just a natural growth. If you look at candidates who are running for governor right now, they're minorities, they're women, so things that we haven't experienced before. So I think there's a natural evolution where that is happening. It's going to be reflected in all our politics.
I mean, if this was Europe, this problem would be more easily resolved, where they vote by parties, but they can, by law, require the party lists to have equal representation for women and minorities. But if we tried that here, not only wouldn't it pass the legislature, but would be struck down as unconstitutional.
So a few of you also wanted to know how big of an issue is this Constitutional Convention going to be in the general elections coming up this next cycle? Is this something that the candidates for governor are going to take different positions on? How much play is this going to get in the general election? Mr. Saxon?
Well, it already has gotten play when the situation with the speaker emerged last week. One of the Republican candidates came out with, I forgot how many points, but a 6 or 7 point, program. And so from the Republican side, it already has been identified. Both Republican candidates in the primary have spoken about a constitutional convention and specific issues they would like to address. I think as a result, it will become an issue in the Democrat primary as well. And I can't project which candidates will take what positions, but it will be, I think, there'll be a lot of political calculus done if they will not be able to avoid the issue.
Okay, we have one question, final question for all of us. Could we have a show of hands of who at this floor would support the Constitutional Convention? Okay, it's pretty popular here. So before we close, I just wanted to give everyone an opportunity on the panel to make any concluding remarks or add to your thoughts if you want to. Starting, I guess we'll start at this end with Professor Tarr.
First of all, again, thank you for inviting me up, and it's been a pleasure being here. I wish you luck with your deliberations. I'll just mention one thing that didn't come up, and that we've seen in some other states, but we've also seen in constitutions abroad. Sometimes you have an experiment and you think it's risky, and you're not sure that you therefore want to enshrine it in the Constitution and therefore make it difficult to repeal. What has been done in some jurisdictions is they put provisions in with sunset provisions, so that after 7 years or after 10 years, you have the opportunity to readdress the question without having to go through the difficult thing of getting an amendment through the legislature or having a constitutional convention.
This point that Alan makes is very important because it shifts the burden from those who want to, with the normal case with something in the Constitution, the burden's on people who want to take it out, and they have to face vested interests who want to keep it in. This mechanism shifts the burden to people that want to keep it in, and that question is decided after 10 or 20 years of experience with the provision. So it's a very interesting mechanism. And this point comes out of a larger study that Al and I did and wrote up a few years ago. We called it Getting from Here to There. And I wanted to say that my perception of this morning is that virtually all of us are, and all of you in Rhode Island for now, are trapped in a box. And on one side of the box is an unlimited constitutional convention, frightening to some people. And on the other side of the box is the legislature, which many people don't think is very responsive. As a part of our study of revision processes across the country, we found a whole bunch of other options. Let me just mention three very quickly. A limited constitutional convention, where you take, and this was part of one of the early questions, couldn't something be taken off the table? Yes, it could. And this has been done in a lot of states to assuage the fears of people who don't want to take the leap of faith. There are a number of mechanisms to do this, and I can go into that. What about a two-step process? We've seen this in Texas, Illinois, a number of other states, Michigan, where they first amend their clause in the Constitution for the mechanism that's used to change the Constitution. Could be used to authorize a limited constitutional convention for people who are afraid of a runaway convention. The experience in the states is that that doesn't happen very much, but so there's a two-step process. Illinois used it to, they couldn't get a convention adopted, so they first amended the Constitution to make it easier to call a convention. Then they used that mechanism. The final thing I'll mention, and there's some others like sunset clauses, putting something in the Constitution that could later be changed by the legislature, maybe by a supermajority vote. This is thinking outside the box that we seem to be trapped in here. And the final thing I'll mention is a commission, a constitutional commission, not the preparatory commission, but a less expensive, maybe expert, not so necessarily representative group that would take some time, study these kinds of matters, educate the public, report to the legislature, but in a circumstance where the commission has raised public pressure on the legislature. People say the legislature will never propose an amendment that limits its own power. It's not true. It does happen. It's not easy, as Steve said, but a blue ribbon or expert commission that really makes the case for one of these things can really make a difference on whether the legislature then proposes it. So one of the things we've said is jump out of the box, think outside the bun or whatever they say, and you can do what you want. This is the power of the people that you have in state constitutional law and that we don't have at the federal level.
I wanted to thank everyone for coming, and thank you for inviting me. I think it's been a really great event. I think whether or not this constitutional convention happens will of course, is in your hands in part, but it depends a lot on whether voter indifference can be overcome and whether substantial opposition by groups who fear the results can also be resisted. So, I'm very curious to see what's going to happen in the next few months, and we'll all be watching.
Mr. Brown?
Thank you. I too want to thank everybody for coming. I'd just like to make one final point about the so-called People's Convention that we would have if this were to pass. You heard about the ad that ran in New York. I think the lobbyists are a little more health conscious these days, not with the cigars and the weight. But we heard, Justice Flanders talked about how big-time lobbyists are the ones who are most concerned about a convention. Well, I think as a practical matter, it's probably true. We all are concerned about change and what it might mean. But I can pretty much guarantee that the lobbyists, the big-time lobbyists, will be among the most happy people if this were to pass, because it will mean twice as much of fees that they will get from clients who need to cover this constitutional convention. PR people, campaign managers, in addition to the members of the public who legitimately and sincerely want to see change, those are the groups, I think, that will also be celebrating if a convention comes to pass.
Mr. Sass?
Yeah, I just first want to thank Professor Tarr and Professor Williams for coming. I found out last night that Professor Williams and I went to the same school, had the same professors, and had better grades. So and also the.
But you played football.
I got paid more. That's what the difference is. Also, I want to thank Roger Williams Law School, Common Cause, and the Legal and Voters for partnering with Brian on this project. I hope it starts something that will continue and follow through from here. On substantive issues, I think Professor Williams was right on mark about thinking out of the box. Unfortunately, to think out of the box, we have to change the Constitution. And one of the issues that we should be looking at and studying closely are the procedures in place for amending the Constitution relevant today. Is there a third way? Because right now there are two ways. Either the legislature puts a ballot on the question, or you have a convention. Experience in other places indicates there might be a third way. So how do you move it to that point? How do we build a coalition to move to that point if there's some validity in that? And the final thing I would say is everything in this world gets back to leadership at some point. We did a project, Brian and the Providence Journal have a project called Job One Leadership, which will be pretty active during the campaign. And a poll was conducted to gauge public attitudes towards the effectiveness of government, not individual candidates or not individual branches of government. And the numbers, you would expect a lot of cynicism, but the cynicism exceeded anybody's expectations in that poll. So there's really an under-churning about the effectiveness of our government in the state. And it gets back to leadership. And I think at the end of the day, the ball really is in the General Assembly's court. I think the General Assembly addresses not all, but some of the issues that we've talked about, then the conversation about a constitutional convention, would be less significant. If the Assembly punts and doesn't do its job, then there are all kinds of risks involved, and we're all looking at different sides of that conversation.
Justice Flanders?
Well, I too want to thank sponsors for this wonderful forum and our guests as well. I just hope that we take the lesson of recent events that we should let no good crisis go unanswered. These are opportunities. Every time we have a scandal, a crisis, a problem that affects us all, there's a real chance to make reforms that in normal and usual times isn't present. I hope we don't squander that opportunity. Again, looking at the Central Falls example, a terrible situation there, but it was an opportunity to restructure the government. They formed a charter review commission at the local level to look at their constitution at the city level, and made significant changes, including changing the number of city councilors from 5 to 7. Term limits were put in, recall provisions, and most significant of all, it empowered the Latino community in that city to get involved in city government in a way they never had before. Now have a Latino mayor, a new Latino-dominated council. That's in a city with 60% Latino population. So again, I look at the changes there, and I'm encouraged that change is possible. Sometimes you have to go through the fire in order to get those changes accomplished. But again, if we seize the moment and make the changes that will lift Rhode Island out of the perennial basement in all these categories that it finds itself, I think that we can all be proud of that. So I'm hopeful that we'll seize this opportunity. And just to make one point about, right now we can't have a limited constitutional convention legally. You could, if they passed an amendment, that would provide for that, but right now, that would not be in the cards, so that opportunity isn't on the table. But, you know, it could be, if the legislature again took the opportunity to pass such an amendment, put it before the voters, we could potentially consider that. So I'm hopeful that there'll be more forums like this, more people will get interested in this subject, and that as a result, we'll have an informed electorate making decisions about fundamental questions like what should our government look like and how should it function.
Mr. Marion?
I want to echo what everybody said, which is thank you to all the sponsors, all the panelists, especially the two professors who came up from New Jersey. We were exchanging jokes about political corruption in New Jersey and Rhode Island. So, and I especially want to thank you all for giving a whole, better part of your Saturday, whether you're for or against. I hope everybody in the audience feels they're going to leave a little more knowledgeable about what what we're facing this November and maybe after that. I also want to emphasize, there were some questions about diversity and so forth. I also hope this is just the beginning. We are just sort of one set of groups and so forth, but that the broader community in Rhode Island takes up this question in the next 6 to 8 months, and that this is just really one of the first forums, one of the first community gatherings to talk about this, and that many other populations in the state do look at this question, whether they're for or against or just want to be educated. And Common Cause stands ready, to help and be a resource if you're a member or know of other groups that would like to do that sort of thing. I'll put a last plug. I won't be able to do it tonight, but I'll also put some of the materials that were available outside up on our website, commoncauseri.org. And if other folks have materials they think are relevant, please get them to me and I'll try to put them up there. It's sort of a clearinghouse for some of this information. I'd urge you to read the law review article that was provided. It's very approachable and well worth reading. So thank you again to everybody for participating.
Well, I just want to echo the thanks, and particularly to our sponsors, Common Cause, the League of Women Voters, the Roger Williams Law School, and most particularly to Bryant University, who provided funding and facilities for this event, as well as the Hassenfeld Institute. So thank you again for coming, and